We're on the record in the case of Taraki versus Shaw, case number D565672. Your name, sir?
Alexander Taratsky.
Thank you. Your name, please?
Tashara Shaw.
Thank you. This is the time set for the plaintiff's motion for issuance of an order to show cause. The defendant also filed a motion for order to show cause, but did not affect service pursuant to EDCR 5.206. So the court cannot go forward on your motion today. And Joseph Houston is appearing by telephone. You may be seated.
Hello.
Hello, Mr. Houston?
Hello.
Mr. Houston? Mr. Houston?
Hello. What's going on here?
Mr. Houston?
That's what. Hello.
Hello, Mr. Houston?
Yes, I can barely hear you.
This is the court. Please hold for Judge Hughes.
Mr. Houston, this is Judge Hughes. We're on the record.
Hi. Hi, Judge Hughes. Yes, I could hear you now. I mean, I must have got a little closer to the microphone or something.
Okay, all right. I announced the case. Both parties are present. We're on the record. This is the time set for your client's motion for an order to show cause. I stated that the defendant also filed a motion for order to show cause, but she did not serve you.
That's correct. We found that out when she gave me some exhibits about 2 days ago that she UPS to me. We found out she'd filed something but hadn't served me.
Right, so we can't go forward pursuant to EDCR 5.206 for improper service. The court's not going to be hearing the defendant's motion today, but I've read the papers for your client's motion for order to show cause.
Okay.
All right, so do you wish to argue the motion?
But the only thing I really have to say is that, we had a long hearing on this. I would have hoped that the defendant had learned her lesson when she took the child and took off and was gone 8 months and tried to say he knew where she was the whole time, which obviously you found was not true. She wasn't supposed to be around the school because she had refused to take the child to tutoring. Even on the day of school, she had the child. We'd agreed to give her a day. And so you just had her picking the child up at 5 o'clock on Fridays. And then what happened is that she went twice to the school and basically kidnapped the kid from school without school officials' approval. The police were called, and it's just a really bad situation where the police have to get the call like someone just stole this kid because the school officials don't know. So we would like to hold her in contempt. We don't want her going to school anymore. And in the exhibits, the worst thing, maybe worse, in the exhibits which we just received, she's apparently going to the school almost every day and taking her new 1-year-old, or not even a year-old baby, to the school and having lunch with the child so the child can't have lunch with her friends. But worse, she's taping the phone calls or taping the things at lunch. She's taping the whole session where she's there at the lunch, apparently trying to get the child at some point in time to say something that she can try to use in court. And there's 2 or 3 tape recordings that she gave me in this exhibit thing she gave me the other day, and we want that stopped. We don't want her going to the school every day. I mean, if there's a special function or a special award that her child's participating in, then great, she can go. But otherwise, she should not be at the school at all, and that should be made clear. And then we'd like to get the contempt order issued and a hearing set on that. She She's living in a house, got a car, a house, everything. She's got to be spending $3,000 or $4,000 a month. Yet she hasn't paid my client even 1 cent of the $100 a month you ordered to pay. So I don't know how she's supporting herself or what's going on with that. Thank you.
Well, the motion doesn't say anything about child support or rearages.
Right. No, I understand.
Well, I take that back. It does say that she's failed to pay, but there's no schedule of arrearages.
Right.
Okay. So, Ms. Shaw, you received the motion from the plaintiff?
Yeah.
Why did you not file an opposition?
What do you mean opposition?
Why did you not file an opposition? On the first page of the motion, it says you have to file an opposition.
Oh, I didn't see that.
Did you read it?
I read the first page, yeah.
You read the first page?
But I didn't see what you're saying is written on there.
Yeah, it says, notice, you're required to file a written response to this motion with the clerk of the court and to provide the undersigned with a copy of your response within 10 days of your receipt of this motion. Failure to file a written response with the clerk of the court within 10 days of your receipt of this motion may result in the requested relief being granted by the court without hearing prior to the scheduled date. It's in capital letters and it's in bold type.
I did not see that.
It's on the first page.
I did not see that.
Why?
I would have responded if I would have saw that.
How did you not see that if you were you
Because I did
received the
not see
motion?
I did not see that. What you're reading right now, I did not see.
How did you not see that?
I didn't see it. I would have responded if I saw it, because this is important.
You received it.
Yes, I received it, but I did not see what you're reading right now.
Can you print the first page of that, please? That motion. Are you taking the child out of school?
No.
Okay. Why did the school file a report that you took the child out of school?
On my birthday, in the court documents, it says that I'm allowed to get her at 9 a.m. to 9 p.m. on my birthday, and I went to the school to get her because he was not going to let me get her.
But she's in school. You
No,
can't
she was
have her
not
while
in school.
she's
She
in
was in the
school.
after-school program.
Okay, look at that page. You didn't see that?
No, I did not see this. I didn't see this page at all.
It's the first page.
Yeah, I didn't see it.
Are you saying that that was omitted?
What does you said omitted as in?
Are you saying that it was not sent to you?
No, I'm not saying that. It probably was. I mean, I have the documents at home.
Okay. The court finds that pursuant to Awad versus Wright, there's a sufficient affidavit by the plaintiff to issue an order to show cause why the defendant should not be held in contempt for removing the child from the school on the 2 dates in question. I believe there were 2 dates, Mr. Taraki?
That's correct.
Okay. And for failure to pay her child support obligation. You have a schedule of custody. You need to abide by that schedule of custody.
So
You are not to take the child out of school. You are to pick up the child on Friday at 5 p.m.
No matter if
That's
it's
your
my birthday or
schedule.
not.
Okay. Friday at 5 p.m. Do you have a copy of the findings of fact and conclusions of law? Because at page 17 it says you're having every other weekend from Friday at 5 p.m. to Sunday at 7 p.m. and on Wednesday from 4 p.m. to 7 p.m. on alternating weeks during the school year. There's nothing about you taking the child out of school. This child
not take her out
has
of
had
school.
learning disabilities. She's had to be tutored because she couldn't even read. She was
could
reading at a
read.
preschool level.
No, she was
and
not.
she was in tutoring. So
That's
there has
not-
been
that's
some
incorrect.
educational neglect,
That's
as the court
incorrect.
found in the findings of fact that this child needs to
And
be in
those are
school.
Hang on,
incorrect.
Judge
So you're
Faulkner.
not to you're not to remove the child from the school.
I did not.
I'm
remove her
issuing
from
an order
school.
today that she's not to remove the
I
child
did
from
not
the
remove
school.
her from the school.
That she doesn't have the authority to remove the child from the school.
I did not.
And I'll
remove her
set
from
an
school.
evidentiary hearing on the order to show cause. All right, Madam Clerk, when is a first available half day and not a trial setting, but
So including
somewhere
my
else?
birthday, I'm not allowed to pick her up. Is what you're saying?
Yeah, somewhere. 30th?
Hello?
Yeah, Yes, I'm trying to look for a date, Mr.
Okay.
Houston.
Okay,
I don't know if you're available on the 30th of December.
that would be fine.
30th of December at 1:30.
And is she ordered to not go to the school except for if there's a special occasion or award, so we can't
I'm
don't
not
have
allowed
this
to have lunch
her
with
trying
my
to take the child every day at lunch with her little baby, just interfering with the child's day and for just being there not for a good purpose, but to be there to try to get some kind of statement
That is a
like
lie.
from the child.
That is a lie.
You are prohibited from taping the child.
I don't tape
You
her.
cannot
We enjoy
videotape
our
the
lunch.
child. You are
together.
prohibited from taping the child. You can
It's
go
our
have
it's
lunch
for
with
our
her
memories.
once a week at the school, but you're not to interrupt her classes
I've
or
never
her
interrupted
school
her class.
work. Do you understand my orders?
I understand what you're saying, but it's not right. It's not right. What's going on is not right.
Okay, hire an attorney.
I am my attorney. I'm the best attorney. I hired 2 attorneys and they both
Okay.
did not help me.
All right. So your
It was
evidentiary
malpractice
hearing.
with both of my attorneys.
Your
They took my
evidentiary hearing
money.
on the order to show cause is at 1:30,
It's not
December
fair
30th.
that you're allowing this
At
man
that
that
time, I
has
will
raped
take
me.
testimony. At that time, I will take testimony, but it will be your burden of proof to show why you should not be held in contempt.
Okay.
Okay? An order to show cause will be served on you that will say specifically what we're in court for on that day. In the meantime, you are prohibited from taping the child.
I don't
You
take
can
her.
go to the school once a week to have lunch
Why
with
once
her.
a week when I'm
but
a
you
stay-at-home
cannot
mom
tape
and
her
I have
and
Listen to
ask
the
her
judge's order,
questions.
because she's giving you an order.
Well, she can get the video if she doesn't hear me because you're being very rude to the
You are
court.
too.
You're showing disrespect to the court.
I'm not trying to disrespect
Okay.
you, but at the same time, this is not right, and we're talking about a child.
Yes, we are. All right. Mr. Houston, you'll prepare the order from today.
Okay, thank you, Judge.
Thank you. We're off the record.
All right, bye.
I don't understand. How can I not be heard?